Now let's take a quiz on these rights of seller, if he becomes an unpaid seller. First, if the goods are rejected by the buyer and the carrier or the other bailee continues to be in possession of them, then the transit dash even if the seller has refused to receive them back. A is deemed to end, B is not deemed to be at an end, C in nobody's hand, D none of the above. If the seller has delivered the goods via some carrier to the buyer, but the buyer is not accepting the goods, even the seller is also not ready to take the goods back. Now what will be assumed? That goods are still in transit, or the transit has ended, or it is in nobody's hand, or none of the above. What will be assumed is as if the goods are still in transit and the transit will not be supposed to be ended. So the answer is it is not deemed to be at an end. Next, when the goods are sold on credit and credit period is not expired, the seller of goods is A, called unpaid seller, B, is not the seller at all, C, not called an unpaid seller, D, none of the above. If the credit period has not expired, he is not an unpaid seller. Let's check. He cannot be called an unpaid seller. Next, where the seller expressly reserves the right of resale in the case the buyer makes a default, if there is loss to the seller on resale, the seller A cannot claim the same from the buyer as damages, B can claim the same from the buyer as damages, C sue the buyer for not purchasing, D none of the above. So, if there is a resale which has happened at a loss, can the seller recover the loss from the buyer? Yes, he can recover the loss from the buyer. So the answer here would be B. Okay. Next, right against goods include A, right of rem, B, right of personam, C, both, D, none. Against goods, it is not against a person, so it cannot be personam, so it is only against right of rem, A option. Okay. Which are not the conditions fulfilled before a seller is deemed to be an unpaid seller? A, he must be unpaid either wholly or partly. B, he must have not refused payment when tendered. C, he must have sold goods against cash or in exchange of other thing. D, he must have an immediate right of action for the price. Which of these is not the condition? The answer is C. It is nowhere written that the goods should be sold against cash or in exchange of other thing. This is not the condition. Okay, so the answer here is C. Sale is a right in rem. A, no. B, yes. C, depends on the direction of the court. D, none of the above. Yes, sale is a right in. It is always in regards to goods. You sell goods, so whatever rights you have against the goods. Okay.